Good morning. It's time for us to resume the inquiry. Yesterday we heard from Mr. Scott and Mr. Williams. Today we'll be hearing from Mr. Ross before we have a roundtable discussion on conditions and obligations before moving on to the site visit. Thank you. Any housekeeping items before we begin? Mr. Henderson?
I think only to confirm so that neither of the parties are going to make an application for costs, so you don't need to allow any time in your timetable on the day of closes.
Okay.
Yeah, I confirmed that my client's position to my lawyer friend yesterday evening, mindful that it may have affected the way in which you need to put questions to this witness. No, we won't be making an application.
Thank you. I received the tabulated form of the conditions. It didn't come through to me as quickly as I would like last night, but I have been able to go through most of it this morning. I'll probably take some more time over lunchtime before we actually have our session to make best use of the time we've got today, but thank you for preparing that. Mr. Tucker, if you'd like to start off with your witness, thank you.
Sorry, I should have raised this during housekeeping. A number of the viewers who are on the live stream are my clients and members of my client's team that are watching from elsewhere. I'm told that when we don't have the microphones on, they can't hear anything. So I'll just raise that again, and it's a reminder of everybody in the room. And also, when you move away from the microphone, apparently it's difficult to hear. So I'm not asking for the inquiry to be rerun on their behalf, but they have asked me to raise that, sir.
So, thank you. Yes, so if everyone can be mindful of that. I know the acoustics in here aren't perfect with a particular echo as well, but we have been persevering. Well, thank you.
Mr. Ross, can I introduce you to the inquiry from page 1 of your proof of evidence? Are you Adam Ross?
I am.
Good. Are you a chartered town planner, a member of the RTPI, Bachelor of Arts? Do you hold a Bachelor of Arts in Honours degree and Diploma of Town Planning from the greatest city in the north of England, Newcastle upon Tyne? Do you have more than 25 years of professional experience as a town planner, and do you appear at this inquiry on behalf of the appellant?
I do.
You tell us at 1.2 that you are a founding director at Nexus Planning, who have now offices in a number of cities in the United Kingdom. I note not Newcastle, but no, that's an expansion plan. Telling us what your previous experience was, and you tell us about your experience across the industry in the succeeding pages. Is that right?
That's correct.
You also tell us at 1.5 about your familiarity with the appeal site and the context within which this application has been brought forward. Could you just give us a broad explanation as your involvement in this case? Are you like Mr. Williams post-appeal, or does your involvement start earlier?
Yes, my involvement goes back to the beginning of the scheme, effectively, both in terms of the preparation of proposals over a number of years alongside some of my colleagues, but also in terms of engagement with the local plan process from the Regulation 18 stage right the way through to the local plan examination and the subsequent modifications and its subsequent adoption. So I've been involved throughout that process.
And just give us a feel for that process. Sometimes one has situations where an application is being prepared in parallel with a local plan process, but there's no interaction with the authority, and sometimes there's a good deal of interaction, and obviously there's a spectrum in between. Whereabouts did this particular scheme fall?
There's been a significant amount of interaction over those period of 3 or 4 years that this scheme has been coming forward. That's both directly through the local plan process, generally in terms of representations made at each stage through that process over those years, but also through discussions with officers and formal pre-application discussions with officers, again, over a number of years. They're set out in a series of documents, one way or another, including the planning statement. The statement of community involvement provides a good summary also of those engagement. It also involved meeting the parish council at one point as well. So it's been a thorough process that we've gone through over a lengthy period of time. And I think an important point to flag as well is the scheme has evolved over that time in the light of comments received and the changes in circumstances that have arisen over that period of time. So I would certainly categorise it as a responsive client or appellant and team in this sense, who's worked collaboratively over a number of years with the council.
Thank you. I'll come back to the evolution and what was discussed at different times in a few moments. I just really wanted to found your involvement at this stage. And during those discussions, has it always been you discussing things with the authority, or has it been yourself and others, or just others?
A mixture of those. Some of the discussions involved me personally, some involved others in my business, and some involved a mixture of all of those. And the client was present during pretty much everything as well. But certainly my company has been involved throughout, and I've been involved in a significant way, but not necessarily in every single meeting.
So questions about history you're in a position to answer?
Yes.
Good. 1.6 of your evidence, please. Could you just turn to that, and then I'm going to come back to the scheme evolution point in just a moment. Could you read that, and could you tell me whether you still stand by that?
I'm aware of my duty to the inquiry, to provide my untrammelled professional view and to present that view irrespective by whom I'm instructed. In that context, I can confirm that the evidence which I've prepared and provide for this appeal is true, and I confirm that the opinions expressed are my true and professional opinions, and yes, I can confirm that remains the case.
Thank you. It wouldn't be the same if we didn't go through our morning ritual, sir. By all means. Right, so let's get a few dates in mind. So first time that this application was intimated to the authority as a potential scheme, when was that in broad terms?
The first meeting with officers, which took place, was in February 2021.
February 2021. Thank you. The local plan adopted earlier this year. Yep.
Yes, it was March 2024, yes.
So during the course of the pre-application discussions which took place between February 2021 and November 2023, when the application was submitted, what was the state of the local plan? What was happening to it?
Well, the local plan was coming forward basically from a period of the Regulation 18. The council had two Regulation 18 consultations, an A consultation and a B consultation. So the A consultation, the very first document, was as far back as July 2019, and it then moved through a Regulation 18B preferred approaches consultation in December 2020, and then got to a Regulation 19 submission draft consultation in October 21. Then was submitted for examination, went through that process in 2020. I forget my years now. Was it 2022 or three? I think it was eventually. Or the early parts of it, 2022 and 2023. Sorry, let me just correct that. It was done in stages, and then had a modifications process after that. So, and during that lengthy process of over a number of years, the allocation of the appeal site was identified ever since the Regulation 18B plan in principle, but that policy amended over pretty much every other iteration of the plan. There were a mixture of either errors or changes which were corrected at each and every stage of that process. So it wasn't a settled policy until somewhere between the proposed modifications and the adoption of the plan, which is back end of 2023 and first part of 2024.
And the capacity of the site we saw yesterday in the Reg 18B document was identified as being approximately 100 in the draft plan. Was that fixed as far as your client was concerned during the process, or was it not fixed?
No, it wasn't fixed. That was the approximate figure that started in the Regulation 18B plan, but obviously that was an early draft plan put for consultation, and my client made representations as they were entitled to do, and as many others did, suggesting that the capacity of the site was slightly higher than was being identified in that plan. Made submissions to that extent, and whilst that process was going on, this separate pre-application process was going on to try and refine proposals. So that there was an interaction, or should have been an interaction, between the two processes that were running in parallel.
And we know the initial design of the scheme showed 125 units.
Correct.
So in relation to that, at what point did it evolve to 112 units?
It evolved to 112 after the receipt of the written pre-application response from the council, which was dated August 2022. It's a slightly unusual one. You may know, so if you look at any of the documentation in this sense, there's a large delay between the submission by the appellant or applicant, as they were then, of making a pre-application request, which happened actually in 2021. The actual written response to that didn't come through till August 2022. So quite a lot was going on in the background, both with the local plan and this in the meantime. But the key thing was that the council offered comments in writing in that response to the submitted proposals, the draft proposals for 125 units. And the appeal team responded to those comments, took them seriously, and amended the proposals to deal with the issues that were raised. And the consequence of that was the capacity of the site reduced to a maximum of 112 units, and that's the scheme that's now before you.
Now, we know there are putative reasons for refusal in this case, and a statement of case in this case, which takes issue with the figure of 112 not comprising approximately 100, and I'm going to ask you about your view on approximate in a few moments. But when was the concern first raised with you that 112 was other than in accordance with criterion 1, paragraph 1 of the policy in the at the time emerging and then adopted local plan?
The first time we were informed that the submitted scheme was in any way unacceptable to officers was in May 2024, just 6 months after the submission of the planning application. And I should probably clarify, it was raised at that point also in the absence of any technical information to support that view. And in fact, the information the council did have at that point was the appraisal of, I think it was the review of our landscape and visual appraisal that was produced by Peter Radmel Associates on behalf of the council. It's a document that was referred to a number of times yesterday and the day before, and as was discussed, that wasn't a document that actually supported the council's position. We put forward it supported our position actually. So, but as a matter of fact, it was May 2024, but in an unsubstantiated way from our perspective.
And if the inspector wants to see further details, that's discussed on your page 9, paragraph 410, is that right?
Sorry, bear with me. So page 9, did you say?
Page 9, paragraph 410.
Yes, it is. Yes, in section 4 of my evidence, that's right.
Now, we know there was an appeal against non-determination because we're here. Why was an appeal against non-determination lodged rather than reducing the number down to a lower figure, say 105, as we heard was within the parameters of approximately 100 yesterday?
Two reasons, principally. The first one was an awful lot of technical work had gone into the proposals that were before the council, as I say, evolved over a number of years, and we consider them and still consider them to be technically robust. That's the first reason. The second one is, as I say, the council officers made it clear they didn't support the scheme, but in our view couldn't substantiate that view in any technical way. So we saw no basis for amending the scheme, particularly in the light of the government's objectives set out clearly in numerous places in the framework, including Paris 123 and 129, to make efficient use of land.
Yeah, and we'll look what the local plan has to say about that in a few moments. Right, common ground first of all. To what extent is it common or uncommon ground between the parties that residential development on parcel A is or is not acceptable?
It's common ground.
To what extent is it common ground that the use of parcel B in part for the SUDs and in part for open space, is acceptable?
Yes, that's also agreed.
Thank you. To what extent until yesterday did you understand the position in terms of whether there were benefits arising from the delivery of Parcel B as public open space?
There are very, very clear benefits to the delivery of that open space. I think my position on the weight and justification for that weight to that open space is set out in my evidence. It's also set out clearly in the planning statement of common ground. There was some discussion yesterday which seemed to alter the weight that I thought was agreed, and I'm unclear on the basis for that, but I think it's set out clearly in my evidence and the statement of common ground.
Thank you. The appeals site is located within the settlement boundary. To what extent do countryside policies apply directly to the appeals site?
They don't.
Thank you. To what extent can objectives within countryside policies be of relevance? Indirectly, if you will.
They can be indirectly relevant in terms of the impact of the appeal scheme on adjacent pieces of land or designations. I accept that, but not directly to the site itself. It's not a valued landscape, for example, or within the local landscape area of local landscape value of itself.
So just thinking about the exercise that went through the local plan stage and also the exercise now before the inspector in this inquiry, which is a balancing exercise constrained by paragraph 11 and by section 38.6. To what extent should one make any assumptions with regard to the level of harm arising from the allocation of this site for approximately 100 homes when assessing the harm that arises from the appeal proposals?
Well, it's clear, and I believe common ground with reference to Mr. Scott's evidence at paragraph 31.2 and 32 that the local plan process involved a balance of development needs in the borough against the harms and benefits of various allocations, and the appeal site is one of those, and therefore the benefits and harms associated with the development of approximately 100 homes on the appeal site have already been deemed to be acceptable. That's what the local plan has already established. So there is a level of harm baked in to the allocation already.
Thank you. Let's turn to policy. We know the resolved position in the delegated report is that there is a conflict with two policies in the local plan. We know what Mr. Scott's view is, that there's a conflict with other policies in terms of the plan. Let's look at all of those. Firstly, overall, what is your view in terms of whether there is conflict or not conflict with policy local plan review, so LPR SA 248, the allocation? Is there conflict?
There isn't a conflict. My evidence addresses so in detail, particularly at Appendix 3, because it's a very lengthy policy with a number of criteria to it, and sets out the compliance with all of the criteria in that policy.
Thank you. Let's just have a quick look at that, shall we? So it's page 282 of core document 2.1.
Yes.
We know that there is said to be conflict with a couple of the criteria within this policy.
Yes.
We also know that the policy's got, 27 different criteria.
Yes.
Oddly referred to as conditions, although none of them fall within section 72, so I'm going to call them criteria. So in terms of the difference between yourself and the council, in terms of those criteria not cited by the council, do you understand that there to be an issue or not an issue as to whether they're breached?
I understand it to be that the council accepts that we comply with the criteria, other than those that it's raised either in that in its intended reason for refusal or in Mr. Scott's evidence.
Okay. When looking at whether a proposal conflicts or complies with the policy, how do you approach it if there's tension with some parts of a policy?
It's necessary, in my view, to look at the policy as a whole in the same way that you look at the development plan as a whole in assessing compliance. So particularly in a policy that's as lengthy as this one with, as you say, 27 individual criteria, one way or another. Were there to be, and it's not my case, I think that we comply with all of them, but were there to be a conflict with one, two, or more, arguably, of the criteria, that isn't a default position of a failure to comply with the policy read as a whole. Of judgment would need to be taken on what the alleged conflicts were, the extent of the harm that comes from those conflicts, and then balanced appropriately, and a judgment taken one way or another. So there's not an automatic position whereby failure to comply with the criterion results in conflict with the policy. But to be clear, my position is there is no conflict with the policy, even taken criterion by criterion.
So let's take two examples in relation to that answer. Let's assume the inspector concludes that 112 is just outside of the range of approximately 100, and that 33.4 is just outside the range of 30 dwellings per hectare. Let's assume that's the case, and there's tension with criterion 1 and criterion 2 of the policy, but he's satisfied that there's not conflict with anything else. What's your overall view as to whether that should amount to a conflict of the policy?
Firstly, it doesn't result in an automatic conflict with the policy. A judgment needs to be taken across the whole, the policy as a whole. I think from the evidence I've read and heard, in this case, there would be, in that assumption, there would be a conflict with two of the criterion of the 27, and a judgment would have to be taken on, well, what's the harm of being not approximate to 100 units. I think we've heard in this case, certainly up to the 112 that are being talked about, that there's no perceptible difference anyway, but that's the process I would suggest would need to be gone through, but it's obviously not a process I've focused on because I consider it to be compliance with the policy.
Let's grapple with this issue of the approximately 100 dwellings. Let us assume that you look at no other policy other than this policy, and we see the words approximately 100 dwellings. Mr. Scott tells the inquiry that could mean plus or minus some degree of tolerance around 100. Do you agree or disagree with that?
Yes, taken in isolation, the word approximately means it could be a number higher or lower to some extent than the stated figure.
Do you agree or disagree with his point that it's a matter of judgment in the circumstance of the case as to whether or not a given proposal is or is not approximately 100?
It is a matter of judgment, yes.
Do you agree that it could be plus or minus in relation to 30 dwellings per hectare?
Sorry, I missed the last...
Do you agree that the same point applies to the approximately 30 dwellings per hectare? Just looking at this policy.
Yes, exactly. It applies to both. Any use of the word approximately, yes.
Now, your point is, read in context, that this policy should be viewed as being a minimum of 100 and a minimum of 30 dwellings per hectare. Could you explain to the inspector why, read in context, you say that's the approach that should be taken to this particular policy?
Yes, of course, and I think that's the key thing. What I'm not seeking to suggest is that the word approximately and minimum mean the same. They don't. But what I'm trying to do is provide context, as Mr. Tucker says, to that reference to approximately. And my evidence sets out some of the context, or key elements of context to that, which I'll just summarise quickly. It did come up yesterday to some extent. But you have reference, for example, in policy LPR SS1 to a minimum housing requirement for the borough as a whole, and it's noticeable that the housing trajectory at Appendix 1 of the local plan, which is constructed presumably using the approximate figures in the plan because that's all that exists, it doesn't actually meet that minimum requirement. So to meet the housing requirement of the borough and exceed it, which is the objective, you would need to, and sites would need to exceed the approximate figures somewhere. So that's a relevant part of the context in my view. There's also policy LPR SP10, which again identifies a minimum housing requirement for the Yalding neighbourhood area. So bear with me a moment. It's a rather large local plan, apologies. There we go. Yes, it sets it out as a minimum, and the relevance here I make is obviously this site is not allocated through a neighbourhood plan or anything similar. It's a local plan allocation, but this policy is setting out a minimum for the Yalding neighbourhood plan area or neighbourhood area of 100 units. And as I've set out in my evidence, the council's evidence indicates that there are no other suitable sites in Yalding to contribute towards housing supply. It's only the allocated site that's the subject of this appeal, one way or another. So to exceed that minimum based on that, it would be this site that had to exceed 100 homes as things stand. And finally, so you've got, again, it was raised yesterday, policy HOU 5, which is a borough-wide housing density policy, which specifically identifies, again, minimum density requirements for the borough and sets out that the reason for doing that is to comply with national policy. And for larger villages that include Yalding, that minimum density requirement is 30 dwellings to the hectare. So when you put those things all together, that's the basis on which I say, yes, the figure for the appeal site specifically is an approximate figure, but I think it's reasonable to take it as an approximate minimum, and I think there would need to be a very good reason, a very strong reason to bring forward a development for less than 100 homes.
So just to see how that last policy slots into the overall assessment, page 282 of the plan, we find the allocation policy, which is relevant to Kenward Road. If you turn a couple of pages further on, you get to chapter 9, development management policies. You see that?
Yes. Sorry. Yes.
285, and you've got the title, how do development management policies link to strategic policies? Do you see that?
Yes.
And then we've got a table afterwards, development management policies and relationship with strategic policies. And then we've got theme housing, and we see LPR HOU 5 tells us density of residential development. Do you see that?
I do.
And if the inspector wants to see how that's intended to operate, can you read the opening paragraphs of that chapter?
Is this parad 991
to 9.4?
9.1 to 9.4, of course.
And within that, do you see any exclusion for any of the allocations from the application of the development management policies?
Fine, I'll read them and come back to that. So the purpose of the second part of the local plan review is to set out the development management policies. That's this chapter 9. The purpose and parameters of development management policies are outlined in national planning policy. It indicates that development management policies are non-strategic policies that deal with a range of detailed issues. They're also part of the policy framework alongside the strategic policies previously outlined. I'd stress there, I guess, the word alongside. They aim to achieve the delivery of the vision, strategic objectives and overall strategy of the local plan review through shaping and aiding the consideration and determination of development proposals. And another relevant reference there. The policies aim to deal with detailed issues relevant to planning decision making in the borough. Generally, they provide further detail to the thematic strategic policies. Specifically, they help decision makers to review the acceptability of certain types of development. In order to focus the approaches on design and sustainability related matters, the Council will produce a design and sustainability development plan document. And then under the heading, how do development management policies link to the strategic policies? The policies set out in this section do not cover all policy areas, and where principles of development are addressed by national policies or in the strategic, thematic and place-based policies contained earlier in this document, they are not repeated. However, the Council considers it prudent to group its approaches to the development management policies by theme. The themes are in line with the strategic policies contained within this document, which in turn are consistent with those themes identified in national planning policies. And then there's a reference at the end to the link between the strategic policy and non-strategic policies or topic areas highlighted in table 9.1, which is the table you just took me to. Going to the question you asked, there's no indication that these wouldn't apply to the appeal site at all. They're quite clearly there to sit alongside the strategic policies of the plan.
Thank you. And just to be fair about the point, when judging minimum density, to what extent does one have regard to the particular character and appearance of a particular site under consideration?
Sorry,
it's all
let's
right.
wait for the chime.
The portentous bell. When applying HOU 5, to what extent should one have regard to the particular characters of the particular site and the effective development?
Yeah, sorry, you referred to the policy HOU 5 itself at the end. Yes, that's correct. It does have that caveat, yes.
Right, good. Let's just go back to policy SA 248. You told me your view in relation to 112. You told me your view with regard to density. you've told me that you consider there is compliance with 1 and 2. Criterion 5, firstly, in relation to matters of landscape and visual issues, do you rely upon the evidence of Mr. Williams to form your view?
I do.
Thank you. So in terms of the substantive point about whether the proposal is informed by an LVIA or an LPA, as a matter of the substance of what's happened, is that a matter for Mr. Williams or a matter for you?
In terms of the substance of it, it's a matter for Mr. Williams. I can confirm as a matter of process that landscape work was integral to the production of the plans that are before you today, because either me directly or my company were involved throughout that process. But in terms of the substance of it, Mr. Williams deals with that.
So in terms of that middle subordinate clause, has the layout form of the housing element been informed by an LVA, in this case incorporating both boundary and internal structural landscaping?
Yes, it has. Read sensibly, yes, it has.
Thank you. Does this policy require you to set out an audit trail to demonstrate that anywhere?
No.
If anyone wants that audit trail, would that be available to the council?
Sorry, I missed it.
If anybody wanted that audit trail, would that be available to the council?
We could make it available if it had been asked for.
Yeah. Would the council be aware of what's happened in terms of the interactions?
The council would absolutely be aware of the meetings we've had with them and the submissions we've made to them and the responses they've given.
Thank you. So compliance or conflict with SA 248 taken as a whole?
Compliance.
Thank you. Next policy, we have policy, where are we? LPRSP 15, where there's said to be issues in terms of design which arise because of matters of landscape and design. If Mr. Williams is right, is there a breach of the policy?
No, there isn't.
Thank you. Does the policy require absolutely every criteria to be met?
No. It's another judgment would need to be taken.
Another judgment. Thank you. That's helpful. The spatial strategy policy, policy LPRSS1, the one that seeks to conserve and enhance relevant landscapes.
Yes.
You said a few moments ago the allocation bakes in some harm with regard to countryside and landscape. Help me with a sense of the position that there is said to be a conflict with policy SS1 arising from the development of the appeal site if the inspector concludes that there's not a lot of difference between a scheme of 100 or 105 and 112.
There isn't conflict with this policy. Yes, so the only relevant element in terms of the site's context, and it applies to that, is this criterion 14 of the policy, which effectively relates to impacts, in this case, on landscapes of local value. And the evidence of Mr. Williams is clear that there is no negative impact in this regard, and I think actually he concludes there will be a beneficial impact through the removal of polytunnels and the creation of a substantial northern landscape buffer. I think that's actually one of the buffers that Mr. Kirkpatrick for the council actually agreed would do its job effectively.
This is from the northern side?
Yes, sorry, parcel A, the northern boundary, yes, which is the boundary closest to the LLV.
And we also had policy SA14, capital A, flagged up. Does that add anything further to the debate in your judgment?
No, it's the same point about a purported impact on the LLV. So if there is compliance with one of those, there'd be compliance with both.
So, taken overall, what's your view as to whether there's compliance or conflict with the development plan taken as a whole?
In my view, there's clear compliance with the development plan as a whole.
Now, there's a spectrum of different views the inspector might take, and the inspector might come to a conclusion that there is some conflict with a policy, and might come to the conclusion there's a conflict with the development plan taken as a whole, for whatever reason. Are there benefits which arise in this case that you set out in your proof, which might justify a different view if there was a conclusion that we were in the section 38.6 position that permission should not be granted?
Yes, there clearly are. As you say, that's not our case, but in that proposition, such that a balance of harm and benefit was required, yes, there's a demonstrable package of benefits. They're set out, sir, in section 9 of my...
Helpfully set out in your 9.2 table, is that right?
Sorry, in...
Yeah, I have them on your page 34.
Yes, sorry, I was page before that. Yes, they are. There's the summary there of the benefits and the weight that I've given to them, and the preceding paragraphs explain why I've given the weight I've given to them. And I believe, well, I'm slightly unclear now, if I'm honest with you. Certainly a number of those benefits I had thought I had agreed the weight that should be given to them with the council. It seemed from yesterday, there's certainly from Mr. Scott's evidence, there's a change of position. I'm unclear why there's a change in position, and I'm unclear actually which position is followed. I think through re-examination, Mr. Scott was taken back to the original weightings he'd agreed in the statement of common ground. So if that's the maintained position, which I would hope it is, there's actually commonality between us on 2 or 3 of the benefits. Actually, there's just a bit of a disagreement, I think, about, for example, the benefit of market homes in the context of Maidstone Borough, but I think I've set out in my evidence clearly why I give it significant weight in this case.
So there are benefits which would weigh on the positive side of the balance in the event the inspector considered that there was a conflict with the development plan taken as a whole. Obviously, it's not possible for you to know what the degree of harm would be, etc.
Yes.
And that's not your case as to whether there was that. So I can't ask whether those benefits would outweigh without knowing what the harm would be.
Correct.
But they would be factors that the inspector should take into account. Is that right?
Correct.
Thank you. The presumption in favour of sustainable development, we spend our time at inquiries talking about 11D, but 11C says the presumption would apply where there is a proposal that accords with the development plan.
Yes.
What's your position in relation to 11C? Is the presumption engaged in that context or not engaged?
It absolutely is, and I say I'm asking this inquiry through you, sir, that these proposals that do accord with an up-to-date development plan, which was only adopted in March 2024, should be approved without delay. That's what it says, and I would agree.
My learned friend, in opening the case, pointed out how well the council is doing at the moment, and it doesn't have a deficit against a 5-year land supply. What's your view in terms of bringing forward a development plan compliant proposal of this nature at this stage, in terms of what the overall plan strategy is seeking to do?
Well, I think looking back, it is correct to acknowledge the council has had high levels of delivery, but moving forward, it's reliant on a new local plan looking forward to deliver homes. With reference to the housing trajectory in the plan, Appendix 1, it's quite clear the plan relies heavily on sites such as the appeal site, smaller sites that can deliver in the early years of the plan period, because a number of the very large sites it's allocating have inherently long lead times and won't deliver any housing for a number of years. So this site and other sites of a similar scale allocated in the local plan are fundamental to the council's ability to maintain a 5-year land supply moving forward in a plan-led situation. It was something the inspector was very worried about actually through the local plan process, and he actually required the council to adopt a stepped housing trajectory because he was very concerned about their short-term ability to deliver housing and didn't want them to have to be going straight into planning by appeal on unallocated sites. So I think it's absolutely important. We're in a well-recognised, I don't think anybody disputes the fact we're in a housing crisis anyway. I think housing has significant weight in any context, but I think clearly in Maidstone context as an allocated site reliant, or the council is reliant on delivering in the short term, it's a benefit of significant weight.
So let's just think about how that plays out. Appeal dismissed for 112, but we know from the authority's perspective that something approximately 100 will be acceptable. Appeal dismissed in, let's say, 6 to 8 weeks, and the appellant is sent back being told it's not in accordance with the development plan and you need to come back with something about half a dozen units less than you have at the moment. How long will that take in terms of getting a consent from this point onwards?
I don't know. There'd obviously be a process of the appeal team would need to go and revisit the entire scheme and associated documentation to reflect a smaller scheme, be submitted to the council. That will take many months from experience here, and the outcome of that, again, I'm unclear on, because there was no indication from the council that these proposals were unacceptable until 6 months after submission of an application. So I don't know.
Well, let's look a figure out of the air. Let's assume 18 months, say.
Okay.
Just looking that out of the air, not saying I'm giving evidence, so I can't give evidence. What would be the sense, in the context of what you said about the importance of small sites coming forward in the step trajectory, of sending the appellants back with a flea in their ear to go away and drop the scheme by a dozen or half a dozen units?
Yeah, it would make no sense in that regard, and I think actually it wouldn't even be necessary, because in that scenario, so I think it would be, if you felt that the capacity of the site was a maximum of 105 homes, for example, I think you'd be perfectly entitled to add a condition to any planning permission to say that it would be wholly consistent with the description of development of up to 112 homes. But I'm not inviting you to do that, because I don't think it's needed at all. It would just simply reduce the contribution that the site could make to market and affordable homes, which I don't think is a benefit to anyone.
Thank you very much. Would you wait there, Mr. Ross, please?
Can my learned friend confirm that's not part of his case, that a condition should be imposed to reduce?
Thank you. I seem to be making good progress through, so we can move on to cross-examinations then. Thank you. No. Yeah, if we're willing to gamble on that one and see what we can get doing, it's just that one does become increasingly frustrating.
That's okay. It's more the sound I'm struggling with every now and then than being able to see, to be honest.
Right, Mr. Ross, let's just run through, please, quickly, topic one, the chronology, how we got here. The site was initially nominated by your clients at Hallam Land in the call for sites, which ran between March and May 2019, correct?
In call for sites, I think that was probably right.
And at that time, it was put forward for a nominated capacity of 165 units across both the north and the south parts of the site.
It was.
That was reflected, for example, in the draft SHLA in December of 2020.
The draft SHMA?
Yeah, in 2020, December 2020.
I wouldn't have thought the SHMA would deal with
The SLA.
Oh, SLA, sorry. Yes, yes.
Yeah, thank you. We then move forward to December 2020, we then get the second round of Reg 18 consultation, and in that we saw this site draft application for 100 dwellings.
Yes, I'm struggling.
Okay.
There's a sort of crackling.
Okay.
No,
Yeah, I mean, if it's this one, then let's try a different one.
I can't turn my mic.
Is that better, Mr. Ross? Can you hear that better?
No. It's the crows.
Okay. Is that better for you, sir? I want you to be able to hear you. No, that's fine. It's very difficult when you're talking to know how it sounds. So we dealt with the call for sites. December 2020, we get the second Reg 18 consultation, draft allocation, And that draft allocation was for 100 dwellings at a density of 30 dwellings per hectare, yes?
Yes, it was. Sorry, my microphone turned itself off. Yes.
You made representations on that draft on behalf of your client, and you said at that point in time 120 dwellings is the capacity, yeah?
Yes.
We then get in June 21 your pre-app request, 125 units on the northern parcel only, yes?
Sorry, would you mind just repeating the...
Yes, June 2021, your pre-application advice request, and that was on the basis of 125 units on the northern parcel.
Yes, correct, sir.
We then get Reg 19 draft, that's October 2021, and again, still 100 dwellings at a density of 30 dwellings per hectare, yes?
Yes.
We then get October through to December 2021 consultation on that Reg 19 plan. Again, you objected to that policy on behalf of your client, and you said, amongst other things, that it should be an allocation of 125 homes, yes?
Yes.
August 2022, you then received the written feedback from the council, yes?
Yes.
The council said that it was not content with a scheme of 125 units in quantum, yes?
Yes.
And as I understood your evidence, that was the point in time where you changed tack, yes?
Yes, that's where the reduction, a response was submitted to officers taking on board the comments raised, and the output was a reduction in capacity.
Right. What then followed in May 2023 with the hearing sessions dealing with Yalding, yes?
Yes.
You attended and made representations, yes?
On that session, yes.
September, sorry, did you maintain your position as in your Reg 19 submissions? Did you say to the inspector, look, this should still be 125?
That was our written submissions to him.
Yeah, and you maintained that May 23?
At the hearing sessions, it became clear that the inspector was focusing on a range of other factual and other errors, both with our policy and the plan as a whole. And so we left it, I left it as a written submission to him at that
You left
point.
it to what you'd put in writing,
Yeah.
fair enough. September 2023, we get the main modifications published, yes?
Yes.
Maintained 100 dwellings at 30 dwellings per hectare, yes?
Yes. Although it amended it to approximately 30 dwellings per
It
hectare.
did, that's right, yes, fair enough. And it also included the modification of the policy text to refer to internal landscaping, correct?
It did. It also was correcting as part of that, just for context, because it's quite confusing when you look back for anyone who wasn't part of it. There were various references to errors in the wording that hadn't described the site correctly, and that's where the whole parcel A, parcel B clarity came from, and yes, the text you're referring to.
Sure, we'll come back to that, don't worry.
Okay.
November 2023 then is the main mods consultation.
Yes.
And then 28th of November, end of the month, you submitted the application and it was validated, correct?
Yes.
And at the point of submission, the plan obviously was not adopted, but you said it had substantial weight, didn't you, the allocation?
Yes, the wording was effectively settled at that point in our view.
Now, in the plan statement, we can look it up, CD 511 please. Go please to paragraph 6.4, page 14.
So could you just give me the reference again?
Yes, it's CD 511.
511,
That's
planning
paragraph
statement, yep.
6.4 on page 14.
I do apologise, my internet is not picking up that document for some. I do have a hard. Well, that's thinking about. I do have a hard copy.
Have you got a problem with the crawl docs?
It's been working fine.
Okay,
I don't know
well,
if I've got
no,
problems.
let's pause and try and get it fixed because we're going to need to look at a number of them. So
Yeah, actually, I think the internet.
I don't want to carry
Yeah,
on if there's an issue.
Yeah, do you mind just give me a sec? It does look like it's
can we
the.
just get this fixed for the Mr.
It does
Watts
look like
so
it's the connection. I thought it was maybe just that document, but it's not. It's not opening.
just take your time. Let's get it fixed.
Yeah, thank you. Actually, I think it. Actually, it may just be that document, actually. Apologies, that's still not. Can I just clarify it's working for others? Because then if it is, it's literally just me.
Mr. Scott, can you get on CD5?
If it's me, I might just need a couple of minutes just to try to
No, that's
restart
fine.
my computer or find the hard copy. But it sounds like I'm going to need.
No, we'll take our time.
Is it
Yeah,
just,
Mr. Scott can get on, so I think I'd rather, because we're going to need to look at not just this, but a whole series of other documents.
apologies, if you just give me a second, I'll
Let's just have a short adjournment then, 10 minutes till 11 o'clock, and hopefully we'll have that sorted out. We're adjourned there, thank you. Okay, if we can resume the inquiry now, please. Have we been able to resolve the technical difficulties?
I have, so I've swapped computers with one that seems to work, so thank you for bearing with me.
Thank you. Thank you, then. Mr. Henderson.
So we were going please to CD 511, which is the planning statement that you prepared.
Yes.
And within that document, can you go please to paragraph 6.4 on page 14?
6.4. Yes.
And you're addressing here the allocation. We see that under the second subheading policy LPRSA 248. And then in paragraph 6.4, first sentence, you say that the proposed development comprises up to 112 dwellings, which complies with the policy requirements of the development to be approximately 100 dwellings. Did you make that statement on the same basis and the same understanding of the policy, the allocation policy, that you provided your evidence to this inquiry?
Yes.
And did you advise the design team about the planning policy requirements for this site?
Throughout the process, yes, as that policy was emerging and evolving, yes.
And when you advised the design team about this policy, did you advise the design team on the same basis as you've given your evidence to this inquiry?
So
Yeah. So put it very simply, you've told this inquiry you think this is a minimum figure. When you advised the design team on this policy, did you say to them that 100 units was a minimum figure in the policy?
No, that's, as stated, and I hope I gave some context to it. It recognised that the council's consistently used the word approximately. There's a wider context about it being minimum, but I didn't brief the team that 100 was a minimum. I think the process was a different approach. It came through the iterations that you've made reference to, that the proposed number of homes has come down from figures established based on technical work and assumptions that have just evolved based on comments from the council and other parties. So it's come down from that process rather than me setting a floor figure.
Okay. I understand you didn't set out a floor figure. Did you advise the design team, though, on this policy, on the allocation?
Not effectively. No, the scheme. The appropriate way to look at this is the scheme, as I say, was the comments came from the council as part of the pre-app response in August 2022. The scheme those comments were based on was amended to deal with those comments, and that led to the scheme of 112 houses. I then took the view that happened to be consistent with the council's position of approximately 100. So I didn't need to inform the development team to do anything to the plan, because I took the view that that was the case, as I still do.
So I understand that, thank you. That follows, therefore, that the development team didn't have the benefit of advice from you on the allocation when they were working up the plan, correct?
They didn't develop the capacity of the site based on an emerging figure at the time. I was aware of that. That was my role in the team, was to be aware of that. I was engaging with that process. I was more bothered by the fact they were doing a robust job based on the landscape and other inputs to come up with a scheme that made efficient use of land, responded to the site's constraints, and ultimately dealt with the issues raised by officers.
Thank you. The figure of 125 dwellings, that is not a figure that you consider to be approximately 100 dwellings, is it?
That's not a matter that's in my evidence. It's not the scheme that's
here.
Here.
Look at your proof, please. Go to your proof of evidence.
Yes.
Within that, I need you to look, please, at paragraph 6.12.
6.12.
And you'll find that, let me give you the right page number. That is on page 18. No, sorry, it's a bit early. I apologise. Page 13.
Yes.
6.12.
Yes.
Look, 4 lines from the bottom. The maximum quantum of development proposed by the appeal scheme is well within an envelope of plus or minus 15%, which I would contend is consistent with the descriptor of approximately 100 dwellings.
Yes.
So if you think the envelope is plus or minus 15%...
No, just to be clear, that's a statement of fact that the proposal is within plus or minus 15%. That's not me saying that's the tolerance of the word approximately.
Right.
I haven't engaged with that because we don't have a proposal for any more than 112 houses.
Sure, but 112 is 12% more, it's not 15%.
Yes, I used it as a rule of thumb that they're both within 15%, just it was a rounding up from, but you're correct, the housing numbers are 12% above, and the density is approximately 10% above.
Okay, so...
I'm happy to amend that if you'd rather me be more specific on that. I was just putting it as a rule of thumb, using the number 15.
So do you consider that 125 is within the range of approximately 100 dwellings?
I'm not sure what benefit that has in this inquiry of me taking that view when there isn't a scheme of 125 in front of the inspector.
So do I take it from your answer that you think what approximately 100 means depends on the scheme? Is that right?
No, I think it has to be considered. What I'm not here is giving evidence on a scheme of 125 houses. I'm giving evidence on a scheme of 112 houses, and I do say that's approximately 100. I'm not ruling out the fact 125 could be approximate, but it's not something I've dealt with here, and it's not something I'm giving evidence on.
So do I take from that it's not something that you can assist the inquirer with then?
I don't think it's relevant to this inquiry.
Not for you to decide relevance, but is it something that you can assist the inquiry on?
No, I don't.
And I take it from the answer that you've given that you haven't considered before I've asked you today whether in fact 125 was approximately 100.
Why would I have considered that?
Please answer the
question.
Sorry, take it from
I'm
the
asking
answer.
a question. Sorry, I apologise.
I take it from the answer that you've given to... Yeah, sorry, sir.
I'm normally quite fairly free with these things, but I'm normally looking for a yes, no, and then a qualification to a question. So if you can be forthcoming and helpful, that would be much appreciated. Thank you.
Apologies, sir. No, I haven't considered it because this appeal scheme isn't for 125 houses.
Okay. Topic 2 then is your approach to the allocation as you set it out today. Go please to the local plan CD 2.1 and look please at the allocation on page 282.
Yes.
Approximately is used 4 times, as we know, twice in paragraph 1, twice in paragraph 2. Do you accept that, looking at those paragraphs, on their face, the ordinary meaning of the word approximately as it appears there is simply a number which is close to 100 dwellings or close to 30 dwellings per hectare?
Yes, I think approximately has its normal meaning in that policy in isolation, yes.
And confining yourself to this policy, an approximate figure could be above or below 100 dwellings or 30 dwellings, couldn't it?
Taking this policy in isolation, yes, that's right.
And again, looking at this policy, the word approximately doesn't mean at least, does it?
Apologies, I missed what you said at the end.
Yes, so looking at this policy on the same basis, the word approximately does not mean at least, does it?
No, it means approximately.
So your case, therefore, is that approximately means something different because of its context, right?
No, approximately means approximately. I accept that position. That's a fact. What I've tried to do is provide context to how you might interpret that, yes, but it doesn't change its definition.
Okay.
I accept.
But you say because of that context, we have to read approximately as being an approximate minimum.
I think that's a fair reading of the plan as a whole. Yes.
Let's look then, please, at the policies you rely on. The first one is LPRSP 10, so that's on page 132 in the same document.
Yes.
The first paragraph 1 of this policy, sets out the housing requirement of 19,669 new homes, and that is expressed as a minimum, isn't it?
It is.
And the reason it is expressed as a minimum is so that it can't be interpreted as a cap. That's right, isn't it?
Correct.
It's not expressed as a minimum because there's an obligation to provide more, rather it's to prevent anybody saying, well, you only have to go up to, correct?
Yes, as you said originally, it's not to be implied as a cap. That's exactly right.
Thank you. Now, move please to policy LPR-SS1, which is on page 33, same document. Paragraph 1.
Yes.
Yes, page 33 is policy LPR-SS1, same document. Paragraph 1. Between 2021 and 2038, provision is made through the granting of planning permissions and the allocation of sites for a minimum of 19,669 new dwellings.
Yes.
The fact that provision is to be made through the grant of planning permissions and allocations, it indicates to us, as we know, that allocations are not the only source of supply. That's right, isn't it?
No, there would be windfalls, things like that are outside.
So
but
you said no, but you're agreeing with me.
Sorry, did I? Apologies.
No, it's fine.
For clarity, yes, there would. Although windfalls, of course, local plans make allowances for those.
And again, if we turn over the page to paragraph 4, new land allocations that contribute towards meeting the above provisions are identified on the policies map. And again, they are allocations which contribute towards, they're not allocations which meet. That's right, isn't it? Because there are other sources of supply.
That is right. Windfalls in addition to allocations, yes.
Yeah. Now, go back to, with that in mind, go back please to SP10, which was page 132. And
Okay.
I want to look now at paragraph 3 on page 133, which deals with the trajectory.
Yes.
Appendix 1 of this plan shows the trajectory for delivering new homes over the planned period, including the breakdown of supply by aggregated source. This is a snapshot in time, and delivery progress will be monitored annually through the AMR.
Yes.
That was a snapshot because it recognised that the position was not fixed and it would develop over time, correct?
Yes, that's the position at the point the local plan was finalised, yes.
And let's have a look at that, please. That trajectory is in the same document at page 376.
Yes.
And if you look at the final row, please, it starts cumulative balance. Do you see that?
I do.
And if you go along to the right-hand side, you'll see there's a red number, minus 279.
Yes.
And we get to that because the annual supply is 19,390, which is 279 short of 19,669, yes?
Yes.
What this shows is that the plan did not precisely match the allocations and the other sources of supply to that minimum requirement figure, did it?
It didn't, no.
And the inspector commented on this in his report. So CD 4.1, please. And look, please, at paragraph 335, which is on page 86.
Sorry, could you just bear with me? The minor technical issue because I borrowed someone else's computer. It's now frozen, or it's locked.
Okay,
And
let's get it unlocked.
I need someone's password just quickly to unlock it, if that's all right. Is that okay for?
No, please.
Is that all right?
Get it sorted.
Putting it on power, will that keep it on? Okay, thank you. There are some advantages to paper versions of everything. Right, brilliant, thank you. Right, apologies.
So when you're...
Sorry, you're taking me to the... If you mind the core document reference, the
CD
inspector's report?
4.1, please.
4.1.1. Yes.
4.1, it's page 86, paragraph 335. And the inspector comments on this.
So do you mind just bearing with me? So page 86,
paragraph
335. Yes,
and the inspector says, cumulatively, over the whole housing trajectory, a small shortfall of 279 dwellings would arise in the last year of the planned period. Given the housing requirement has increased significantly from 17,746 dwellings on plan submission to a modified figure of 19,669 dwellings, the scale and time of this shortfall is not critical to overall plan soundness. So the inspector didn't, for example, go on and require further allocations or adjustments to make good that shortfall, did he?
No further. He'd already made very substantial changes to the housing strategy in the plan, and he didn't make any further changes, no.
And the inspector was not insisting on a rigid match between the sources of identified supply and that figure of 19,669, was he?
No.
And the reason why was because he'd recognised that even getting up to 279 demonstrated a plan that was significantly boosting the supply of housing, yes?
He did.
Now, on the council's approach to approximate, some of the allocations may deliver above the starting figure, some of them might deliver below. You accept that, yes?
That could happen.
Yeah. Look please at CD 4.6 and go please to page 35 of that. This is the AMR.
Okay, so what's the paragraph reference? Or page?
It's page 35 and it starts at paragraph 3.23.
3.23, yes, I'm there.
And it's under the subheading indicator M13 density of housing. Do you see that?
No, sorry, could you just talk me through where? So
Yep.
paragraph 3.23.
And you see it's drawn a little diagram and some figures, and then above that it says indicator M13 density of housing.
Yeah, oh, so, yes,
You got
above
it? Yeah.
Above it, yeah.
And what this tells us, the first sentence, between 2016-17 and 22-23, within the town centre and urban area, plan permissions have been granted for developments of considerably higher densities compared to the target set out in the adopted plan. And then it gives us the table below, table 12, and we see by way of example, sites within and adjacent to the town centre got up to 245 dwellings per hectare. Other
Yes.
sites within and adjacent to the urban area got up to 87, and sites within and adjacent to the rural service centres and larger villages, that was 28 dwellings per hectare. Do you see that?
Yes.
The pattern which this shows in the period 2016-17 through to 22-23 is one of essentially over delivery on sites within the town centre and the urban area, exceeding the expectations of the plan, correct?
Yes, that seems to be what it's saying.
And we know that in that urban area, cumulatively, 60% of the growth which is planned for in the local plan review is to be in that area, yes?
Yes, I believe that's right.
And therefore, this trend suggests that a number of those sites are likely to over-deliver, doesn't it?
Possibly. I'm not sure you can automatically assume that. It shows a past trend, not a future trend. What I wasn't involved in either, so there's a limit on how much I can comment on this, is the examination process relevant to town centre sites and urban sites, because the local plan makes allowances for development. You can see it in Appendix 1 in the housing trajectory. It makes allowances from the town centre. I don't know what allowances were made as part of that, so I think there's a limit about how far I can draw conclusions about what that's saying.
Let's just chase that down a little bit more. Go back to CD 2.1, please, and go to policy HOU 5, which is on page 296. You've looked at it already,
Yes.
I think. Look at paragraph 1, dealing with town centres. Do you see that?
Yes.
New residential expectations 150 DPH. Do you see that?
I do.
So substantially below the 245 DPH that's been recorded, yes?
Yes.
And the second paragraph, 75 DPH in an urban area. Do you see that?
Do.
And again, materially below the figure of 87 DPH recorded in the AMR, yes?
Yes.
So what we have is a policy that is setting conservative requirements as against a pattern which shows actually in these urban areas the likelihood is you're going to get more. That's right, isn't it?
It does say that, and the only comment I'd make as well is that I think that's our position about the density approach on our side. The local plan does adopt a conservative approach.
But the telling thing about the urban area compared to the countryside is the difference. So go back to the AMR, please, that we looked at 4.6. Look at what is assessed in respect of sites within and adjacent to rural service centres and larger villages. Do you see the average DPH there?
I do.
It's 28, isn't it?
Yes, it's also it's got apologies, but it does have years at 2016 to 2017. The average was 33. That's the density, the maximum density we're proposing.
Sure. But
2021.
Of
So
course.
2020 to 2021 was 32. Same again in 22, 23. They're almost identical to what
Of
the
course,
maximum density we're proposing.
but it's more robust, isn't it, to look at this over the period of the whole monitoring period? That's the more robust approach, isn't it?
Well, I think it depends what point
Well,
it's trying to be made about average.
I'm dealing simply with your point here, because in contrast to the urban areas where there's a clear difference, actually the trend data and the expectations in the allocation and HOU5 are much more closely aligned, aren't they, for countries?
Yes, I could accept that point.
Let's restart it, yes. Having regard to the fact these are in the context of allocations which some will be above and some will be below, those are both factors which point away from reading 100 dwellings at 30 as a minimum, don't they?
I'm not sure I agree, because if you start taking that approach across all of the sites in the plan that refer to approximately and say it should be another site somewhere else that goes above approximately, we don't need to here, we can go under, you'll undershoot the figure in the local plan by even more than it already does.
Now look at, back to SP10 please, on page 134. Go please now to the second part, or the last two paragraphs of this policy on page 134, dealing with designated neighbourhood areas.
Yes.
The first thing to say is that the purpose of these paragraphs is to respond directly to paragraph 67 of the NPPF, isn't it?
It does say that.
Now, in terms of that, can we have a quick look, please, at what NPPF 67 says? So CD 1.1, or you might have it separately. And it's on page 18 of the NPPF.
Thank you. Okay, I'm there.
The first two sentences dealing with setting the strategic housing requirement, and then the third sentence is the one which we're interested in. Within this overall requirement, strategic policy should also set out a housing requirement for designated neighbourhood areas, which reflects the overall strategy for the pattern and scale of development and any relevant allocations. Do you see that?
Yes.
So that's the context. We go back to the policy, please. CD 2.1, same page that we were on before.
Yes.
First thing, paragraph 7. What this says, as a minimum, and as set out in the table below in the supporting text, designated neighbourhood areas are required to accommodate housing from any site allocations within their designated neighbourhood area boundary, or part thereof, as contained in section 8 and appendix 1 of this LPR. Do you see that?
Yes.
So what this is doing, and the table confirms it expressly, if you turn over two more pages to 136.
Yes.
Yalding LPR SA 248 100 units. Do you see that?
Yes.
And what that is saying is that the neighbourhood plan needs to accommodate the allocation, and that's the allocation which is in section 8, yes?
Yes, it has a minimum housing requirement which must include
No.
the appeal site.
No, the minimum housing requirement is in the final column. We're looking at the second column. Look at the second column.
Okay.
So
Okay, let's take it in chunks then, sorry.
Yeah, so that's exactly, we're working through part
Fine.
7, then part 8. So part 7, the purpose of part 7 is to say that the neighbourhood plans need to come forward consistently with the allocations in section 8.
Sorry, where are you reading from?
Paragraph 7.
Oh, sorry, back in the policy, right, sorry.
Yeah, paragraph 7.
Yes.
And one of those allocations that's relevant to us in section 8 is SA 248, and we know that because it's in the table.
Yes.
So that's what part 7 is doing, paragraph 7. And if we just think about why that's the case, if you got the PPG, it's CD 1.2, you have to click through, so hopefully you can.
So CD 1.2.
Yeah.
I can find it, yeah, sorry, it's, again, because I'm not using my computer, it hasn't got my...
I think what we've done in the core docs is just put the link, so hopefully you can...
Oh, was it? Oh, I could see the sheet of paper, is there a link? Oh, there is, you're right.
The link will take you through, I hope.
You're right, thank you. Yes, sorry, yes.
Yeah, and do you see there's the section dealing with neighbourhood planning?
Yeah. Yes.
And can you go please to paragraph 44 within that, 044, easier to do a word search perhaps than get there.
Sorry, 044.
And you see the subheading, can a neighbourhood plan allocate additional alternative sites to those in a local plan?
Yes.
So do you have that? I'm sorry, it's a bit of a paper chase, but that's the nature of the PPG. .044, so it's about halfway. And it's so let's just work through this, please, Mr. Ross. A neighbourhood plan can allocate additional sites to those in a local plan or spatial development strategy where this is supported by evidence to demonstrate need above that identified in the local plan or spatial development strategy. Neighbourhood plan should not reallocate sites that are already allocated through these strategic plans. Yes?
Yes.
So applying that obviously here, don't reallocate your site.
Yes.
Fine. Let's keep going. A neighbourhood plan can also propose allocating alternative sites to those in the local plan or spatial development strategy where alternative proposals for inclusion in the neighbourhood plan are not strategic, but a qualifying body should discuss with the local planning authority why it considers the allocations set out in strategic policies are no longer appropriate. So this gives rise to the possibility of switching allocations. You understand that?
Yes.
The resulting draft neighbourhood plan must meet the basic conditions of it to proceed. National planning policy states that it should support strategic development needs set out in strategic policies for the area, plan possibly to support local development, and should not promote less development than set out in the strategic policies. Nor should it be used to constrain the delivery of a strategic site allocated for development in the local plan or spatial development strategy. Now, we have your site as an allocation local plan. Policy SP10 that we were looking at is a strategic policy, isn't it?
Yes.
And therefore, what policy SP10 does, plus SS1, is ensures that for the purposes of neighbourhood plan making, your site in the allocation is considered to be a strategic site allocated for development in the local plan. Yes?
Yes.
And the benefit that that gives to your allocation is it prevents a neighbourhood plan coming forward and putting a constraint on delivery, doesn't it?
Yes, it wouldn't be able to do that.
Exactly.
Yes.
And in that context, when we go back to, I should say, it also prevents the issue of neighbourhood plan trying to swap you out for someone else, yes? Because you're strategic, you're in there.
Yes.
So if we go back then to CD 2.1 and paragraph 7 that we were looking at a moment ago,
Yes.
the inclusion and the cross-reference to section 8 and then the table of your site is to make sure that that's a strategic allocation which is protected from any tweaks like that in the neighbourhood plan stage. Do you understand? Can you agree?
Yes, absolutely. I certainly really, yeah, any neighbourhood plan, if there was one coming forward, would need to.
But what paragraph 7 is not doing is it's not amending the allocation. Instead, it is protecting the allocation. Do you see?
It does have that consequence, but it's a strategic allocation, and the neighbourhood plan can't override it. I read that paragraph far more as saying to a neighbourhood plan body that they would need to plan for at least that allocation is coming forward as part of the local plan. They would need to make additional allocations above that minimum if they wanted to.
Yeah. Well, if they wanted to make allocations, they'd have to make additional allocations. We can agree that. But slightly more than that, what this is doing is saying you can't touch the allocation. Yes, you understand? That's the purpose of the reference here.
I'm not sure I read it as the purpose of that, but I think that's the function of a strategic allocation, yes.
Because if we just look at paragraph 7, there's nothing here within paragraph 7 that seeks to amend the allocation SA248, is there?
No, it wouldn't do.
And to the contrary, it simply puts in the cross-reference of section 8, and then we get the cross-reference in the table again, correct?
Yes.
Right, let's move to paragraph 8 here, please. Paragraph 8, any future designated neighbourhood areas will be expected to accommodate as a minimum relevant housing requirements from site allocations in the LPR, policy LPR, SP8, garden settlements or strategic development locations. Now what this is doing, it's dealing with the housing requirement for any neighbourhood area, isn't it?
Yes.
It is not dealing with the requirements on any particular site, is it? It's on an area-wide basis, yes?
Yes.
And it doesn't seek to amend any of those other possible policies. It cross-refers to the allocations, it cross-refers to LPR, SPA, it cross-refers to the garden settlements, doesn't it?
Yes.
And in that regard, it is not an amendment, it is seeking to act consistently, isn't it?
Yes.
And then in respect of the table, let's deal with your final column. Total minimum housing requirement figure at the top, that is for the neighbourhood plan area, yes?
Yes.
And then when we look at the, for Yalding specifically, that's where we get 100, yes?
Yes.
And in light of what we've just agreed, that is 100 for the neighbourhood plan area, isn't it?
Yes.
And that is set as a minimum in the same way as policy SS1 is, so that you don't read that as a cap. So the neighbourhood plan form can't say that's a cap. That's the reason it's expressed as a minimum, isn't it?
Yes.
It's not expressed as a minimum in order to modify or alter the allocation, is it?
It's not seeking. No, maybe I wasn't clear earlier on. I'm not suggesting anything modifies the allocation itself. I just provide it as the wider development plan context to that policy.
Because the point that flows from this, just to wrap up on at that point, is that we know what the ordinary meaning of the words the policy in isolation are. You've agreed all of that, that's very helpful. You've got to show that it has a different meaning in context, and when we look at the first bit, SP10, SP10 is a policy which acts consistently with the allocation. It doesn't seek to alter or amend or give a different meaning to the allocation, does it?
It doesn't, but just to clarify,
thank you.
My point, what I'm not suggesting is that the inspector needs to take, I'm providing wider context as to how I think you should interpret the figure. We're not reliant on that because my case, is that we are up to 112 units is approximate to 100, irrespective of its context. That's my case.
I get
to
that.
it. That's just adding some colour to how I think it should be interpreted, but I'm not reliant on the inspector sort of trying to redefine words or policies to get to that end.
No.
112 units is approximately 100.
Now the other part of the context, of course, is the spatial strategy. We looked at SS1, but it works through a series of policies. So the next one we have to look at is SP7, larger villages. That's page 113.
Okay, sorry, bear with me. Yes.
And we're specifically focused on Yalding, and part 1A, focus new development within the settlements when it is 1A, an allocated site in the local plan. In terms of understanding what the allocations in Yalding are, we then need to move forward to SP7D, and you find that on page 120.
Yes.
And part 1 tells us that as a larger village of Yalding, as shown on the policy map, key services will be retained and supported. And part 2, in addition to minor development and redevelopment of appropriate sites in accordance with policy LPR SP7, approximately 100 new dwellings will be delivered on site LPR SA248. Do you see that? And this policy LPR SP7D, if we start with SS1, we go through SS7, SP7D, this is the policy that directly allocates our site.
Yes.
The detail of which we see in SA248, yes?
Yes.
And when it does so, it does so on the basis of an approximate quantum, yes?
It does.
So in terms of working through the spatial strategy, SS1, SP7, SP7D, and then SA248, at each of those stages, the picture is one of an approximate figure, isn't it?
It is.
And in that context, when we think about SP10, SP10 is doing a different role, isn't it? It sits outside of the spatial strategy, which is dealing with the housing requirement, isn't it?
Sorry. Yes, housing. Yes,
Yeah.
SP10 is about housing delivery.
Yes, it's not about where we allocate sites, is it?
No.
And nor is it about the nature of those allocations, is it?
No, it's more of a numerical policy, effectively.
Yeah, and therefore, when we look at these strategic policies in the round, the only strategic policy that you point to support your approach is the one that is least relevant because it's not dealing with where and it's not dealing with how much, correct?
Well, I mean, I've set out why I think they are a relevant context. I think the most important one, the policy you haven't referred to there, is HOU 5, which I made reference to in Chief, which also provides clear indication as to why the figure should be minimum.
I'm afraid you didn't listen to the question carefully enough. I specifically said by reference to the strategic policies, because we know HOU 5 is a non-strategic policy, isn't it?
Apologies, sorry.
So I'll put the question again.
Okay.
So by reference to the relevant strategic policies, the spatial strategy ones, SS1, SP7, SP7D, they're all ones that point towards approximately, and the one that you point to, SP10, is the one out of all those spatial policies which is the least relevant because it's not dealing with where and it's not dealing with how much, correct?
It doesn't deal with those issues, no.
Right. And therefore, looking at that context in the round, actually, the context of the spatial strategies, that fairly supports the view that the council takes that this is approximately not approximate minimum, doesn't it, correct?
Yes. But I just would say,
So
I wouldn't. Can I just finish?
Do you want to caveat? Yeah, go on.
Yeah, I worry slightly. We're getting too. I mean, I've provided context to my interpretation of the approximate figure, but the primary case is based that 112 homes is approximately 100, irrespective of its context, one way or another. So I wouldn't want this. I'm happy to keep answering questions, but I just want to be clear that that's not the primary case I'm running. It was providing some context. That was what it was intended to do, not to redefine words or policies. The case is that the scheme is approximately 100 homes.
Mr. Ross, I totally hear that, and this is why topic 2 I said at the start is the approach to the allocation. I promise you, topic 3 is.
Oh, that's fine. I didn't know your next topics.
Topic 3 is exactly your point about is 112 100. Yeah.
Okay.
So we dealt with the strategic policies. I've heard your caveat. Thank you. Can we just pick up HOU 5, which is the last one we've got to traverse here. This is a non-strategic policy, correct?
Yes, it's one of the development management policies, yes.
Yeah. And can we look, please, at the text that you looked at in your evidence in chief? So go to page 285.
Yes.
And we see in paragraph 9.4, the policies set out in this section do not cover all policy areas, and where principles of development are addressed by national policies or in the strategic, thematic and place-based policies contained earlier in this document, they're not repeated. Yes?
Yes.
So the approach when we get to these policies is not to repeat that which has gone before. Yes?
That's what it says, yep.
Now, in terms of what has gone before, one of the things that has gone before is the allocation, isn't it? SA 248 on page 282. That is a site-specific policy, correct?
It is, yes.
The requirements of that policy have been specifically tailored to the site, haven't they?
Yes, the criteria of the policy, the site-specific policy, are specific to the site, yes.
So to take your example, in earlier iterations, there was reference to a requirement for a local historic impact assessment, wasn't there?
Sorry,
in earlier iterations, Reg 19, for example, there was reference to a requirement for a local historic impact assessment, wasn't there?
There was.
And that was one of the points that you said, look, we don't need that on our site. That was in your reps.
Yes.
and that was one of the modifications. That was ditched because it wasn't, it wasn't a site-specific matter.
Correct, that was one of them, yes.
Now, conversely, some things like that were ditched, but the thing that was kept in was paragraphs 1 and 2 about how much and the density, and also paragraph 5, the condition there about the requirements for the buffers, for example. Yes?
Yeah, yes.
And if we take condition 5, paragraph 5 as an example, that reference to specifically the internal and perimeter buffers was kept in, notwithstanding there are a number of other general development management policies that kind of deal with similar things, but there was a specific need to refer to that here, wasn't there?
There was.
Well, and that is a good example of how the allocation is the prism through which these more general plan themes, the more general plan theme of protecting the environment, for example, is calibrated to the site. You accept that?
Yes.
And part of that calibration of those wider themes to the site is the balancing of the interest, yes?
Yes.
And that means that this allocation is the hyperlocal manifestation of that balancing exercise, isn't it?
It is.
So in that context, on the growth side of that balance, what the policy provides for is approximately 100 at approximately 30 dph, yes?
Yes.
When we when we go to policy HOU 5, so back to page 296, you want to take us to part 5 of that.
Yes.
At sites within or adjacent to the rural service centres, larger and smaller villages as defined under policies LPR SP1 to LPR SP8, new residential development will be expected to achieve a net density of 30 dwellings per hectare, where that is compatible with individuals set in those sites. First thing to say, no need to repeat what is said before, because as we know from the introductory text that we looked at, the approach here was we're not going to repeat everything we've said before, correct?
Yes.
Second thing to say, when it comes to defining and balancing what is a density compatible with individual settings of those sites, that has already been done at the hyperlocal scale in the allocation policy, hasn't it?
Yes, the approximate figures.
And when that exercise was done at the hyperlocal scale, the output which it came up with was not at least 30, it was approximately 30, yes?
That was the language the council used, yeah, absolutely.
And the reason why it was calibrated differently, approximately rather than as a minimum at that hyperlocal scale, was to reflect the sensitivities of the landscape in which it sits, correct?
In part, I think the council seems to use approximately throughout the plan, for pretty much every single allocation, irrespective of its sensitivity. I think it's just an approach it's adopted. So I wouldn't draw a particular distinction for this site. It's not only this site that has the word approximate and everything else is minimum, it's approximate throughout the plan, apart from, I think, one.
We'll come on to that, but just to finish off then on HOU 5 Part 5, there is no inconsistency between approximately 30 in SA 248 and this policy, because what we need to do is look at the hyperlocal application, which is approximately 30, and when we do so, you don't need to read that as an approximate minimum, do you?
I think reading those policies together, you should be looking at approximately 30, but with a view of exceeding 30 if you possibly can.
A view of exceeding if you possibly can.
Subject to obviously the technical inputs, and that's what I mean when I say possibly can.
And that therefore means you don't see 30 dph as a floor in the allocation?
No, it's approximately 30.
Not a floor, correct?
No, it's in the same way as for the housing, it could be above or below technically.
Thank you. Even having regard to HOU 5, it remains the case it's not a floor, correct?
No, approximate is not a floor read on its own, no.
No, even read with HOU 5. You say
apologies. It's still not a floor.
Still not a floor.
It's still not a floor, but I think it's relevant context to read the policy in, but no, not a floor.
And that's your point about if you possibly can. I understand that.
Yes,
but still not a floor. That's very helpful. Okay, let's just chase down your point about the other policies.
Okay.
Go to
Sorry,
CD 4.1.
4.1.
I haven't overrun yet. CD 4.1, which is the local plan inspector's report, and go through, please, to page 61, IR 236.
236.
Yeah, and this is dealing with one of those other policies in Maidstone Town Centre.
Yes.
And the inspector says this. This is in respect of SA 146. The submitted policy for the site is expressed as providing for a minimum level of development, inferring potentially significant more development could take place. Given the various requirements for the site and its context close to listed buildings, the railway, the busy A229 Fair Meadow Highway, it would be necessary to replace minimum with approximately. And main modification 66 would do this. He recommended it for effectiveness, and it was adopted.
Yes.
Clearly here, the inspector did not consider the word approximately and the word minimum to be doing the same thing. They were doing two different things, weren't they?
Yes.
If we were to read approximate as an approximate minimum in our policy, then they would be doing the same thing, wouldn't they? They'd be both minimums, correct?
So, sorry, would you mind just
of course.
repeating or rephrasing? I didn't understand.
We know the inspector's approach is when you say the word approximately, you don't mean minimum.
Yes.
On your approach to the allocation, you think it should be an approximate minimum, yes?
Red is the plan as a whole, yes.
But that's the case that at least your client's been put forward so far. If that is the approach, then that would be a contradictory approach to the inspector here, because it would be to read the two words as being the same, whereas he was very clearly of the view that they were not. That's fair, isn't it?
No, I don't think there's any conflict between what I'm saying and what he's saying. There is a difference between the word minimum and approximately. I don't know the context of that specific site, but the inspector clearly made a change from away from minimum to approximately for whatever reasons he chose to. There is a difference between the words. There must have been for him to have made the change.
Yeah.
Or I'm not seeking to suggest that approximately means anything other than I think what we all understand it to mean. There's a dispute on judgment as to how far the tolerances of that go. But
okay, so let me ask you one more question on this. Well, I'm very grateful for the intervention, sir, because my concern is paragraph 4 of my learned friend's opening, and he says this: Mr. Ross shows how, when the plan is read as a whole, the reference to approximately 100 dwellings can only sensibly be referring to an approximate minimum figure, and the word minimum has been emphasised. That is the whole purpose of this line of questioning, because that is, as I understand it, not only my learned friend's case as he opened it, but also what my learned friend says Mr. Ross's evidence is. So I think it's perfectly fair. Now, I'm grateful for the clarification. If my learned friend's not going to say in closing that it means approximate minimum, I can simply leave that line of questioning there. Oh, please.
Thank you, sir. So our case, it's set out in opening, is a summary of the case. I know my learned friend opened it twice the length of mine, but it's still a summary of our case. Our case is not that you read 248 in isolation as meaning anything other than the word approximately. Our case is you have to read other parts of the plan together with 248, and the conclusion is the correct approach to a site of this nature, or indeed other sites, is to have regard to those parts of the plan. For example, HOU 5, which suggests that there's an expectation of there being a minimum density. That's it, top and bottom. That's what the witness said in chief. That's our case.
Very clear, part of my learned friend can confirm. Even read in context, the appellant's not saying it's a minimum figure, correct? Even in context.
Right, I'm not going to be cross-examined by my learned friend. Hold on.
I'm not getting a great deal of illumination from this discussion, I'll be quite honest, there. I know you have a number of topics that you want to get to, and I suspect we're probably coming to the conclusion of this particular topic anyway, are we? Yes. So if we can...
In that case, I apologise for interrupting.
Like Catherine said, I was simply going to put open to the request, but we've already covered it, so I don't need to do that. So topic 3 now is the application. Do you want to break now? So is that where you were?
No, I'm okay for a break. I'm quite happy to plough on.
Okay, let's keep going.
Thank you.
Topic 3. Let's take this hopefully a bit more quickly. The plan seeks to balance growth with the protection of natural assets, doesn't it?
Yes.
And that is because of the high quality environment within the borough outside of the urban areas, yes?
Yes, I think the foreword to the local plan
Exactly.
says something
So
along those
I was
lines.
going to say taking you there, but yeah,
right, yes,
you're ahead of me, Mr. Ross. That's very helpful. The provision for housing, including the allocations, represents the product of that balance and exercise, doesn't it?
Yes, the plan as a whole is a consequence of that exercise. Yes.
And in respect of larger villages, we know. And I do want you to look at that, please.
Okay.
CD 2.1 and the relevant policy is LPR SS1 on page 30. Sorry, wrong page number. It starts on page 33 and it's page 35, paragraph 11.
Sorry, bear with me. Yes, so paragraph 11. Yes.
And in the context of that balance, the role of Yalding is to be a location for limited housing development consistent with the scale and role of the village, yes?
Yes.
The allocation in Yalding SA248 is the only allocation, isn't it?
Yes.
It is therefore an allocation which is an example of limited housing development consistent with the scale and the role of the village, yes?
Yes, the council's agreed, as did the inspector, that approximately 100 houses at Yalding is consistent with that approach, yes.
And the limited approach that we see in respect of this tier in paragraph 11 is not one which is reflected in, for example, the tier above, rural service centres, is it?
No, because larger villages sit below rural service centres.
Indeed, nor indeed in garden settlements, Maidstone urban area, or which are in paragraphs 5 and 6 in the tiers above. Again, not a limited approach there.
No.
Now, when we turn to your judgment of what is approximate here, we have to judge approximately in the context that this is a location for limited housing development, don't we?
No, I'm not sure. Yes, any development would need to meet the terms of paragraph 11. As you say, that's the strategy for but limited. So the only definition of limited is what the council's done, and that's in the context of Yalding, it's approximately 100 houses on this site.
And if this is a site which is, as we've agreed, an example of limited housing development, then it's appropriate to look at approximately on a similarly limited basis, yes?
No, I don't think so. I don't see the link between the reading across between those two things. A scale of growth which could not be considered to be limited would be contrary to paragraph 11 of the policy you took me to.
Yeah.
If that's what I would agree with that premise, but I wouldn't agree that you interpret the word approximately in that context. Approximately means what approximately means.
But when you're forming your judgment, do you have something which is approximate? We know that in the context of this village, the amount of deviation can only be limited because otherwise you're going to go beyond what is envisaged, correct?
No, I don't agree that you can read across from one of your assumptions to the other.
And it follows that a 12% increase in quantum is not a limited approach to the scale of this development, is it?
I think it absolutely is, most fundamentally because 112 is approximately 100. So by definition, on my case, it complies with both the allocation and the strategic requirement for what's referred to as limited growth at larger villages. I think it's completely consistent.
And in the inspector will hear what you say, and in considering your judgment, he will have to bear in mind that you can't give him a sense of parameters. So you can tell him what you think the answer is here on this specific set of numbers, but you can't help him with what you think it means more generally, can you?
I don't, and I don't think it's helpful for me to do that because we only have one scheme in front of this inspector.
Now, okay, that's very helpful. Topic 4 then, the other development plan policies. CD 2.1 policy LPR SS1, which is on page 33. This is a, sorry, are you there?
Yes, I am, sorry.
This is a relevant policy, yes?
Yes.
Paragraph 14. This is a policy which seeks to conserve and enhance landscapes of local value, yes?
Yes, criterion 14 does, yes.
Yeah. If there's harm to a landscape of local value through development in its setting, then that is development which would fail to conserve and enhance it, yes?
Yes, if that harm existed, yes.
Yeah. And that conflict would arise irrespective of whether the development in its setting was in or outside a settlement boundary, yes?
Yes, I think my confusion at the time I wrote my evidence was in terms of I had not understood and hadn't really till very recently the council's case on whether countryside policies applied to the site directly, and that's why I was unclear about the reference to this criterion and some other references. I think if it's being read in, yes, the context of the site and its impact on adjacent land is relevant, I would agree.
Yeah, thank you. And in this case, if the inspector considers there is excess harm to the Green Sand Ridge LLV beyond that anticipated by the allocation, that would give rise to a breach of this part of the policy, wouldn't it?
No, I don't think so. I think the issue would be whether the LLV was conserved and enhanced. I don't think that's what that criterion says. If it was for greater level of development was proposed that still conserved and enhanced landscape value, it would still meet the terms of that criterion, wouldn't it? I think. Sorry, I've rephrased it as a question.
The fault may be mine. If the inspector concludes that there's excess harm to the LLV beyond that which is anticipated by the allocation, and as a result of that harm the landscape is not conserved and enhanced, that would be a breach of this policy, paragraph 14, wouldn't it?
If it wasn't conserved and enhanced, yes.
Thank you. Now, in respect of policy LPR SP 14A, so page 197, again, a relevant policy, yes?
Bear with me. Yes, a general policy about the natural environment, yes.
Paragraph 1B, protection for positive landscape character, including landscapes of local value, again, relevant, yes?
Yes.
If there is excess harm arising to the LLV beyond that which is anticipated by allocation, that would give rise to a conflict with part 1B here because there would not be the protection of the LLV, correct?
I'm not sure you can. I think I'd probably give the same answer as I've just done before to the previous policy in terms of what's required. Yes, if a judgment was made that it didn't protect positive landscape character, including local landscapes of local value, there would be a conflict with that criterion of that policy. A judgment would then need to be made on whether that constituted a breach of that policy read as a whole, and the development plan as a whole. Okay. But yes.
Well, let's look at that now then, please. So that's topic 5, hopefully, the plan and balance, and we'll start with this issue as a whole. Go please to the allocation, PDF page 282, same document.
282. Yes, I'm there.
Right, paragraph 1.
Yes.
The first sentence, that defines the scope of the allocated development, doesn't it?
It's the introductory first criterion, yes.
Yeah, no, but it defines the scope of the allocated development because it tells us where it's going to be,
yes.
It tells us what it's going to be for, and it tells us, it gives us the parameters, yes?
It does. I'm being careful with my language here because I think there's a fundamental difference between us as to how you interpret this policy, so that's why I'm being careful.
Do be careful.
Sorry, do you mind just... pausing till that's finished
Sure.
striking. It's right. Apologies.
So the starting point when we're applying this policy is to think, do we have a development that is within its scope? Yes.
Yes, you'd apply criterion 1 first of all.
Because if, for example, we had, take a very extreme example, an employment use, that would obviously be outside the scope of the policy, wouldn't it?
Yes, it would be contrary to criterion 1 and 2.
And in that case, if you're outside of the scope of the policy, it's not a question of do I comply with the conditions, because you're not even in the ballpark of applying those conditions, yes?
No. This is where I think there's a difference between us in the interpretation of this policy. It appears the council are reading this to me as if it were a planning permission, with criterion 1 being the description of development, and then it even uses the highly unusual language, I think, actually, of conditions that it's subject to, and they're numbers 2 through to 2027. And this is my point of clarity. As I understand it, I'll leave it to legal submissions if necessary, but I read policies as a planner. I read them all. I read them in context. I read the 27 points. I look at compliance with each and every one of them, and if necessary, a judgment made on lack of compliance and whether with anything, and whether overall there's compliance with the policy. I don't take it that if you don't comply with criterion 1, you conflict with the policy inherently, no matter what. If you had 101 dwellings and that was held not to be approximate, say, I wouldn't. The proposition that's put to me here seems to be that would take you outside the scope of the allocation, and therefore you're contrary to it. No, it's not a proposition I'd agree with.
Take my employment example. You're going to be outside of what is in paragraph 1, yeah?
Yes.
The fact that, for example, paragraph 6, you might be able to design your site to ensure neighbourhood residential amenities protected, or 7, or 8, the fact that you might be able to comply with some of these other conditions isn't going to bring you within the policy, isn't it?
No, I think you would come back and make a judgment as a planner as to the scale of non-compliance. And I think quite clearly an employment scheme on a housing site, that criteria is an important criteria, and therefore I think you would be taking the view quite clearly you'd be contrary to the policy as a whole.
And if we look at it, let's take it back to what we're actually dealing with, which is residential development. The way the policy works is that it tells you in the first sentence what the allocation is for, and then it tells you, and these are the words you've highlighted on, the following conditions are considered appropriate to be met before development is permitted. So the allocation, the what do you get in the first sentence, is conditional on meeting those paragraphs which follow. That is what it tells us in that sentence, isn't it?
That's the language that's used, yes.
Yes. And the reason why it uses that language is because this reflects the hyperlocal balance. You get the growth on the one hand, which is your first sentence, but you only get the growth if you adequately protect, which is the second sentence, and everything that follows. You agree?
I agree with the proposition.
Right.
Absolutely, they qualify exactly in the context of this site, the things that are deemed to be important. I do agree. What I don't agree with is that this was drafted so specifically to mean something particular. These policies were riddled with so many errors. It took the inspector a long time to deal with, and so I wouldn't support some sort of highly legalistic interpretation of that these were deliberately used words that mean something different to normal. To me, this is a policy for an allocation, as you absolutely rightly say. It sets out an approximate scale of development, an approximate location, and criteria that should be accorded with. My case is that we accord with each and every one of them, but I'm just trying to make the in principle point that there's not a necessity on my case to comply with every single one. You could still comply with the policy as a whole. It would depend on fact and degree and a judgment to be made. So I'm sorry to labour the point, but I think that is for the inspector's benefit. There seems to be a difference between myself and Mr. Scott as to how to approach this.
Yeah, that's fine. It's helpful that you explain. I'll make submissions on it. But and you accept though that the second sentence, reading it in its ordinary way, supports the view that I've put to you that all those conditions have got to be met before you get going, yes?
they're the condition. Oh, yeah, I would use criteria, but yes, it says conditions considered appropriate to be met before development's permitted. But to be clear, my case is that we meet them. But
Yeah.
I've set out a wider interpretation.
And if you don't, if they are not met before development is permitted, i.e. before the decision, whether that's at the outline stage or the reserve matters, then you cannot gain the support of the allocation. That's right, isn't it?
No, I don't agree with that. For example, just as an example to try and make my point, sir, if you accorded with all of the criteria of this policy, but let's say you breached number 12, that all landscaping should to be principally native planting. Let's say we read a different type of planting, non-native planting.
Yeah.
The proposition is being put to me that would mean you are contrary to this policy read as a whole, and presumably contrary to the development plan as a whole. I wouldn't agree that that's the consequence of it. I think a judgment is then required as to the significance of that failure to comply with that one criterion out of 27, and take a view on the policy as a whole. And that's a judgment to be made. But I say it's not one I've taken forward, because my case is we comply with them all.
But the problem with your approach, I lean forward, is this. In your example of the native planting, if it's non-native planting, the balance that's been struck, the give and the take, is on the basis that this is going to be native planting, yeah? That's how it's been struck.
That's the expectation, yes.
And what you're asking the decision maker to do is to restrike a balance that was made at the strategic stage, aren't you? Because you're saying, well, we're not going to give you that, we're going to give you something else.
I mean, just to be clear, it's not what we're doing. But in a hypothetical situation where that was what was proposed, all I'm saying is that it's a planner's job. A policy is struck at a point in time. It's a planner's job, particularly on a highly lengthy policy, and usually lengthy policies like this, to take a view overall on what they see. I don't think you apply it so literally that one criteria, failure to accord with one criterion, would immediately and automatically cause you to be contrary to that policy or the development plan as a whole. That's not how I think you would approach it.
And we shouldn't be recasting the strategic balancing exercise in a Section 78 appeal, should we?
And I'm not.
Right, now in terms of the question of compliance with the plan as a whole, if the inspector concludes this is an application that conflicts with the allocation, yeah.
If he did, okay.
Yeah, that's the premise. What follows from that is that there is conflict with the development plan as a whole, isn't there?
I think if in that scenario, I think yes, you would.
Right, thank you. The plan imbalance, the additional 12 dwellings, between 100 and 112, that additional 12 dwellings is not necessary to bring forward development on the site. There's no viability issue, for example, is there?
Our case, no, that's not the case for the scale of developments proposed, no.
Your client obviously wishes to deliver more, and as I understand it, the reason that you're given for that over-delivery is making efficient use of land, is that right?
I mean, I wouldn't characterise it as over-delivery, but...
well, the extra 12.
I wouldn't cast it as an extra 12 either. It's approximately 100, which is what's expected by the policy, but the basis for it, I think we've set out in detail previously, and I think you heard from Mr. Williams yesterday. It's followed a detailed, lengthy design exercise with engagement with various parties to get to that outcome. Yeah, that's why we are where we are.
Sure, but just to be really clear, can you simply tell me why is it 112, not 100?
Because our professional team's technical work that was carried out on site, as you rightly referenced before, considered that actually there was a capacity of 125 units on the site. That was put to the council. We listened to the comments made by officers, adjusted the scheme to take on board their comments, because we were trying to work with the council, given this was an emerging allocation and now an allocation, and dealt with those comments, and dealing with those comments got us to 112, and we shouldn't be doing, in my view, is artificially reducing the capacity of the site below that due to some interpretation, very narrow interpretation of what approximately means.
And I understand that's the top-down approach. Do you rely on making efficient use of land as a justification for 112 as opposed to 100?
It's not. It's a relevant factor. It's not it's not a justification, it's a relevant approach.
Okay.
Throughout, the local plan itself acknowledges that it would refuse schemes that don't in the supporting text of policy HOU 5.
Let me chase that down then. 100 dwellings at 30 dwellings per hectare is not inconsistent with paragraph 128 of the NPPF, is it?
No. Well, I say no. It might. I think it's not in and of itself. Our proposal justifies our proposal as being an efficient use of land that's appropriate, a more efficient use that is appropriate in landscape terms.
And if 100 dwellings at 30 dph is not inconsistent with NPPF 128, then an approach which seeks that is one which equally seeks the efficient use of land, correct?
Sorry, do you mind just...
Yeah,
just
100,
unclear.
if there's no inconsistency, then a development of 100 at 30 dph would be an efficient use of land for the purposes of the national policy, wouldn't it?
Well, possibly taken in isolation. I mean, I think in the context of our application it wouldn't be, because we've demonstrated on my case that you can appropriately deliver 112, so on that basis it would be inefficient to deliver 100.
Yeah.
And that's not what the policy asks for. It asks for approximately 100, not 400.
Your proof of evidence, please, paragraph 8.9, subparagraph 4.
Sorry, paragraph
8.9.
8.9.
And it's subparagraph 4 within that. Which
Yes.
you'll find, it's page 29, I should have said, sorry.
Yes.
8.94, you say the council promotion and adoption of the allocation means that there's already an inherent acceptance of impacts, both positive and negative. And you tell us that this includes an accepted degree of harm to some matters to be able to deliver the quantum of housing identified, i.e. the inherent impacts associated with this scale of development are baked into the allocation of the appeal site.
Yes.
It's not just, because it's an acceptance of both the positive and the negative, it's not just the harms, it's also the benefits that are baked in the way that is envisaged by the allocation, yes?
Yes.
So if the inspector includes that there is either an excessive number, so you're outside the scope, or there's an excess of harm, okay, you're above what's baked in, and he needs to consider, well, is that excess above the baked in amount acceptable, correct?
Yes, the inspector would, on that premise, would need to take a view on the extent of that excess in the way you term it, and probably more importantly, the impact of that excess.
And when you do that, you need to look at both sides of the equation fairly,
Yes.
don't you?
Yes.
And therefore, if you focus in on what is the consequence of the excess harm, you must equally on the other side focus in and say, well, does that give rise to excess benefit, correct?
Yes, you need to look at both sides of the equation, yes.
But you need to look at it in the same light. So if you're considering excess harm, you also then need to think, well, is there any excess benefit above what is anticipated by the allocation to justify that excess harm, yes?
Yeah, I think in the context you're referring to, I think, yes. I mean, so I'll come back to it if I need to, sorry.
Right, now to your proof, please. Paragraph 9.2 on your page 34.
Sorry, my page 34.
Do you see the table at the bottom of that page?
Yes.
The first of those things, 67 market homes.
Yes.
If we take the baked-in approach, the excess benefit is that of 7 dwellings, isn't it?
I think I think we're maybe slightly at cross purposes here. We have one appeal scheme here,
Yeah.
which has a set of benefits attached to it. That's what I'm assessing. That's why it doesn't dice it down at all, because we're not talking about excessive anything. It's in accordance with the policy on my case, and we're just looking at the scheme as a whole and what the benefits are as a whole. Not because I think we went down a problematic route with Mr. Scott at one point about this point about how you attribute benefits to a purported excess.
Think about all of Mr. Williams' evidence on landscape. Yeah, his premise is to say, on behalf of your client, does the 0.2 hectares, the excess, does that make any difference? You understand?
Yes.
Because what he's trying to isolate is does that difference give rise to excess harm, yeah?
Yeah, Mr. Williams was assessing the difference between the proposal and what was assumed, as you say, baked in at the allocation stage, and concluded there was no material difference.
And you carry the same approach through to your plan and balance, because you don't say what is the harm of the scheme overall. You say, well, what is there any excess harm? That's what you do.
No, I think this is where because my case, I think it was mentioned in chief. My case is compliance with the development plan, and on that basis, you don't need to get into benefits versus harm.
I get that.
At all. But that's the premise my evidence is written on. All I'm doing is setting out for the inspector's benefits. If he found something contrary to mine, those are the benefits of the appeal scheme set out, and principally Mr. Williams has dealt with the harms insofar as there are any at all. That's why I haven't gone down the route of saying harm benefit in a different way, because it's not my case based on the evidence I've heard.
If the inspector thinks there is conflict with the development plan as a whole,
Yes.
you invite him to look at the factors in your table 9.2.
Yes.
And you invite, do you say, is it your evidence, to be really clear, is your evidence that those factors would justify a departure from the development plan and grant a plan permission?
Sorry, in the context where it was contrary to the development plan.
Yeah, you say to the inspector, please look at my benefits in this table. Do you go the step further? And do you say, in that context, that plan permission should be granted? Because I think you do, don't you? Your paragraph 11.4.
Yeah, because I speculate as because I just cannot see how the breaches of policy could be so substantial to get you to a conflict with the development plan anyway. I think is also my evidence on it, because I'm being asked to speculate on conflicts I don't identify, so it's very hard to come up with a planning balance exercise on a hypothetical basis I don't advance, and I'm not sure exactly what's being put to me in terms of the breaches.
Well, go to page 38 of your proof, please.
Sorry, page 30.
38, paragraph 11.4.
Apologies, 38.
Because this is your evidence to the inspector.
Yes. Yes.
Your approach here, we'll take it in its proper turn. In 11.3, you say, as you've said now, I don't consider it to be right to do so, but in the event that it's held that council allegations of conflict were robust, that the policy breaches were identified were correct and of such significance so as to conclude that appeals stream conflict with the development plan as a whole, it would then be necessary to carry out a traditional section 38(6) plan and balance to assess whether other material considerations would indicate such a conflict with the development plan would be outweighed by the balance of other material considerations. That's the exercise that would have to be done. We can agree.
Yes.
Then you say, my evidence with reference to the evidence of others demonstrates clearly that any possible conflict with the development plan in the case could only be limited. Oh, I'm sorry.
The crackling of that microphone again. I think it's probably just the acoustics, but I was just struggling to follow what you were saying there.
Let's try that. Is that a bit better? So I was in paragraph 11.3, so I was just picking up the sentence that says my evidence. Mr. Ross, you say this. You say, my evidence, with reference to the evidence of others, demonstrates clearly that any possible conflict with the development plan in this case could only be limited. Yes. Set against such limited adverse impacts in this scenario would be the range of very significant benefits that I identified, which would weigh strongly in favour of the proposed development. That's pausing there. That's your table 9.2.
Yes.
And then you say this, and outweigh any such conflict. And then you go on and you say, accordingly, even in this unlikely scenario, I consider that there would be material considerations that would considerably outweigh any limited harm, that the appeal scheme constitutes sustainable development, and that plan permission should be granted. So you actually do the plan and balance exercise in that hypothetical world, don't you?
Well, I set out the sort of mechanics of that exercise in the event the inspector wished to do it. I sort of I draw it as far as I can, but what I don't do is do that exercise in detail. As you can see, it's only a short paragraph effectively. So my intention was just to cover that in the mechanics of an exercise that the inspector would follow in a certain scenario, but it's not my case, which is why it's not set out at length, because clearly it's a detailed exercise. It depends on I'm suggesting the conflicts could only be limited one way or another. That would go into that balance, but it would depend what conflicts the inspector found. So I'm not trying to be obstructive, but I'm just trying to put in context. I was trying to just signpost how the inspector might proceed mechanically, effectively, in a certain scenario, but it's obviously not my case, so it's not set out in detail.
Come on, Mr. Ross. you do more than just set out mechanics. If you positively conclude, you say, I consider, that must be your view. That must be
Yes.
your professional view. You give your professional view that there would be material considerations that would considerably outweigh any limited harm. So you are saying, I've done the exercise, and that's my judgment, isn't it?
On the premise that I think any conflict could only ever be limited, but I don't think there are any conflicts.
Should the inspector scrub out, in light of your answer, should he scrub out 11.4 and the final 5 words of 11.3? Or do you want to stick by them?
So I could some horrible
Sorry, I'll put the
echo
question.
that I had for a minute, which
I'll put the question again.
it's gone. Sorry.
Should the inspector scrub out 11.4 and the final 5 words of 11.3, or stick by them?
I stick by my words.
So therefore, I'm going to ask you about that exercise. You tell us in detail. You probably need to tell, but in that exercise,
out the